All right, welcome to the third seminar of our Legal Philosophy Between State and Transnationalism series. When I say us, it's Osgoode Hall Law School and the Department of Philosophy under the umbrella of the Nathanson Centre on Transnational Human Rights, Crime and Security. And today we're fortunate to have with us Professor Nomi Lazar, who is Assistant Professor in the Graduate School of Public and International Affairs at the University of Ottawa. Professor Lazar's work focuses on a number of manifestations of the relationship between institutions and human agency, spanning the history of political thought, contemporary theory, and public policy. She is the author of the bestseller, States of Emergency in Liberal Democracies, which was recently published. When was it published? 2010? Nine, at Cambridge University Press. She holds a BA from the University of Toronto down the road, an MA in Legal and Political Theory from UCL in London, and a PhD in Political Science from Yale. And we are very grateful to have her with us today. She'll present a paper entitled New Modes in Old Orders, Crisis Government and the Written Constitution. We're looking forward to this. And as usual, we have a respondent, and today for the first time in this series, our great colleague, Professor Benjamin Berger, who is Associate Professor of Law here at Osgoode Hall Law School. Ben holds a law degree from the University of Victoria, as well as an LLM and SJD from Yale also. His areas of teaching and research specializations are criminal and constitutional law, as well as law and religion and the law of evidence. And prior to joining Osgoode, Professor Berger was at the University of Victoria, both in the law school and the faculty of, or the Department of Philosophy, where he was cross-appointed. And before this, he was a clerk at the Supreme Court of Canada for our Right Honourable Chief Justice Beverly McLaughlin. We're very thankful to you, Ben, for being with us today. And without further ado, I give you Nomi Lazar.
Well, thank you very much, Francois. Thanks to all of you for coming and to the Nathanson Centre for inviting me today. So I'm going to be speaking about prerogative power and what we might call its extreme public relations problem, particularly in the United States, but I think to some extent in Canada as well. In my first book, I posed the question, given that liberal democracies are foundationally concerned with the prevention of domination through the protection of rights and separation of powers, how could the prerogative power in a crisis, given that this power often involves the derogation of rights and the concentration of power, ever be justifiable? In response, I began to develop an argument about the subservience of institutional forms to overarching principles. I developed an ethical political account of the role of prerogative in liberal democratic and republican systems of government. Recognizing the dangers of this mode of political action throughout that book and subsequent articles, I explored an array of modes of constraint on both on this kind of power, both formal constraints and informal, that might show when prerogative could be more or less safe. In effect, I aim to answer both those liberal Democrats and those followers of Carl Schmitt who have argued that liberal democracy is incompatible with prerogative power. In the course of my work on crisis institutions, I've written a great deal about the Roman institution of the dictatorship, and in light of that work, two scholars of American prerogative, Ben Kleinerman and Clem Fadovic, engaged me on the question of how the Romans had justified prerogative power. So they wondered, well, what kind of justifications did they put forth? And at first, I really wasn't sure how to answer. So I went back and I read, reread the main texts, and I thought, and I read some more, and finally came to the conclusion that it seemed that the Romans didn't think that prerogative power was in need of justification in the first place. For the Romans, there apparently was no legitimacy problem with prerogative. And that made me wonder, well, why do we have a problem with prerogative? Why are we so puzzled by prerogative power when so many previous republics and Republican thinkers weren't? Now, it's obvious why we're concerned about specific uses of prerogative power, and I'm certainly not suggesting that we shouldn't be worried about specific exercises of prerogative, their legitimacy and their safety, case to case. What I'm wondering is something different. Why might we think that the very existence of prerogative was illegitimate or incompatible with liberal democracy? So I'm going to use the Roman case to help illuminate this question. While the Romans embraced flexible government and flexible institutions, we are perhaps irrationally afraid of flexible institutions, and this contributes to our fear of prerogative as such. The Romans were at ease with prerogative, but this stands in particularly striking contrast with a common American perspective. Some American scholars of crisis government have gone so far as to insist that no such power even exists in the American system of government, and that no president has ever exercised it. From an outsider's perspective, this seems to be clearly false. Why the difference in perceived legitimacy, or even in the capacity to perceive or accept the very existence of prerogative power? I'm going to argue that this stems at least in part from a fundamental difference in the way in which the Roman and the American constitutions are perceived with respect to the role of flexibility and flux in maintaining stability. Prerogative lets states respond flexibly to novel circumstances, but if flexibility and flux are understood as problematic to begin with, then perceptions of prerogative will no doubt follow suit. The Romans held fast to what we might call a tradition of innovation, a fundamental commitment to evolving institutions which were matched to the times. By contrast, Americans commonly hold that only institutions which are described in a fixed and written constitution can provide stability and a bulwark against abuses of state power. So of course, this isn't the only explanation for our fear about prerogative, but I hope to show it's not least among them. And while I'll certainly not argue that prerogative is always safe, nor am I going to intervene in this paper in current debates about optimal institutional design, arguably, prerogative can at least be legitimate. And here I keep company with a number of American scholars who've argued that either prerogative or some form of constitutional dictatorship is compatible with the Republican Constitution. What I want to add here to that work and to previous work of my own might be understood as a partial explanation of resistance to our conclusions. So I'm going to follow Locke in defining prerogative as action for the public good in the absence of, or even sometimes against, the written law. And like Locke, it's my contention that prerogative is consistent with constitutional government. In Lockean terms, it accords with the law of nature, and in ours, we might say that it accords with the rule of law broadly conceived. The rule of law, after all, doesn't negate discretion, but only requires it to be constrained to the extent possible. And the place of prerogative is exactly here, by definition, where law has run out, but action is required anyway. Prerogative would remain consistent to the extent that the principles governing the execution of the law informed the use of prerogative also. Now, we generally find ourselves talking about prerogative in the context of emergencies and crises, but of course, prerogative is not confined to those kinds of cases. Indeed, with every position or office that we might have in respect to one another, there come implicit or explicit permissions and obligations which are understood to be legitimate to the extent that they meet with an often unspoken but mutually understood set of criteria. Arguably, for example, the American president must have the power to uphold the oath detailed in Article 2, Section 1 of the American Constitution if he has the strict duty to uphold it, whether or not this explicit power is delineated. Prerogative power, where the law is silent and sometimes even in violation of the law, stands as part of a venerable tradition in the legal precedents and customs of constitutions from Rome to Britain, and so its legitimacy is not in any way a radical assertion. I'm here defining a constitution as a set of enforceable rules and procedures for the conduct of government and the relationship between states and citizens. Constitutions delineate the powers associated with an office and the relationship between those offices, and they express, implicitly or explicitly, the principles and values that ground the political community. Now, in most modern constitutions, these rules, procedures, and principles are delineated primarily, though not exclusively, in a variety of written documents. While we may associate constitutions with legislation that is particularly well entrenched, entrenchment can take a number of forms, and some constitutions, such as those of Canada, the UK, Israel, New Zealand, etc., have elements that at first glance seem to be everyday legislation, subject to revision or rejection by simple majority. But formal legal hurdles aren't the only way to slow or prevent change, and conversely, a supermajoritarian requirement isn't confined to constitutional legislation. Technical entrenchment isn't necessary to, nor sufficient for, written legislation to have constitutional status. In addition to these less formally entrenched pieces of legislation, all constitutions have unwritten elements, and constitutional change is frequently extra-legal. This is necessarily the case, in part because no constitution can set out every rule that might be required to operationalize government. And over the course of time, an array of precedents in the form of constitutional conventions or norms arise that translate the written rules into government in action and regulate unforeseen elements of government business. Some of these might become so familiar that citizens may be familiar with the rule, but be totally unaware that the rule was never actually written. The importance of the unwritten elements of constitutions has until recently been underestimated. Among these elements, a central type is the constitutional convention, unwritten norms that regulate the behavior of political actors in a way that's parallel to normal constitutional provisions. These norms are subject to sanction, not legal sanction, but sanction nonetheless, and they oversee a substantial part of how every modern government functions. So if we understand prerogative as power exercised in the absence of or even against the written law in the service of the public good, and we understand constitutions as the rules and conventions that dictate the form, extent, and processes of government, then prerogative could be a coherent part of a republican government, a set of powers exercised when necessary in accordance with normative but often unwritten conventions. And because the flaunting of conventions remains subject to oversight and sanction, there's no reason in principle why the exercise of prerogative could not be subject to accountability too. Prerogative in a constitutional republic is thus, at a minimum, conceptually coherent. But scholars advance a variety of objections to prerogative. They argue that it concentrates power dangerously, that it weakens republican spirits. We hear that kind of objection more often in the US than we do here, that it leads to tyranny, that it's sometimes hard to tell when prerogative is used legitimately. And Americans also sometimes argue that prerogative was rejected by that country's wise founders. So in the paper, I demonstrate that some of these concerns are ill-founded, while others are quite legitimate, but with respect to the problem of specific uses of prerogative, not the legitimacy of prerogative as such. Even the most careful institutional design leaves ample scope for abuse. But as Clinton Rossiter has shown in his history of constitutional dictatorships, the dangers of rejecting prerogative outright may be greater still. For our purposes, what's most noteworthy is that all these critiques, valid or not, are suggestive of danger, not illegitimacy. These two things are not the same. Indeed, every kind of power is potentially dangerous, and that's why we engineer checks and balances to begin with. Free of fear, I may take my daughter to the zoo to see the lions, but if the lions were wandering free, I may have second thoughts. In the paper, I also explore American resistance to the notion that their Constitution allows for the exercise of prerogative. That America's Constitution does allow this is suggested, at least in the decision in McCulloch v. Maryland, and Clem Fadovic has clearly demonstrated the various robust senses in which Hamilton and Jefferson, at least, understood the place of prerogative in American government. Both thought that the American Constitution was not exhausted by its written content. Jefferson, who understood himself to be exercising prerogative in, for example, his purchase of Louisiana, saw prerogative as extra-constitutional because it was without the sanction of law. The virtuous executive, on his view, admits his fault, requests post hoc ratification, and accepts the consequences if it's not forthcoming. So Jefferson's perspective, then, is quite similar to the extra-legal measures model that is in contemporary debate proposed by Orrin Gross. The rejection of a formal institution for the exercise of prerogative doesn't reflect the founders' rejection of prerogative as such, but rather a preference, or more accurately, diverse preferences, for informal prerogative, whether institutionalized or otherwise. It's clear why we are and should be concerned about specific exercises of prerogative power, and why we should design and employ such institutions with great care. I think that's largely indisputable. But it's less clear why we're resistant to the idea that constitutional government should have some form, or could include some form of prerogative, why these two things are consistent, or perhaps even necessarily interdependent. Perhaps one reason for this hesitance stems from the fact that prerogative involves shifts in institutional structure and in the capacities and relations of offices, in ways that bring the tensions between those offices particularly to the fore as well. If we begin from the notion that a constitution is a single written document that delineates one shape for government, then prerogative may seem like an attack on a constitution. America has a form of government on one common view, which was instituted in 1787 and has continued much the same ever since. And in one sense, this is true. There has been remarkable continuity in America's government, but it would be as easy to argue that America's government has altered profoundly in the last 2.5 centuries, that flexibility and flux have, in fact, always characterized American government along with stability. And stability and flexibility are, after all, not mutually exclusive, as the Romans understood. And I now turn to exploring this particular contention. From our best evidence, the Romans seemed at ease with prerogative power. They understood flexibility and stability as intertwined. Given that the Roman example inspired so much in the history of political thought, and particularly in the thought of America's founders, this is a really striking disjunction. After all, the Romans, just like us, valued separated powers and something akin to individual rights and protection from domination. And their republic, like the American Republic, was founded on a story about resistance to tyranny. The Romans didn't fear the office of the dictatorship, partly because in practice it was effectively checked, as I've argued elsewhere, but also because the dictatorship was understood as a legitimate part of their flexible constitution, an extension of everyday consular powers. So I'm going to assume that at least some of you aren't very familiar with the Roman institutions, but I'm going to be quite brief in my little primer, and if you want more detail, I invite you to ask in the question period. So the dictatorship in Rome arose because after the Romans had expelled the Tarquin kings, they needed somebody to take on the jobs that the king had previously performed. So initially, they instituted an office called the consulship. Now, there were 2 consuls, and the consuls were elected by the people, and they held 1-year terms. But it quickly became apparent, within a decade or so, that some higher form of magistracy was necessary to deal with special circumstances and crises. The consuls functioned under a great many constraints, which the kings had not had to contend with, and some of these specifically interfered with the effective execution of strategic and critical action in an emergency. And it's also important that the consuls were generals and that Rome was pretty much constantly at war, and that meant that the consuls were not infrequently dead or far away when they might be needed elsewhere. So the dictatorship was instituted to fill in these gaps. Very briefly, the Senate would issue a senatus consultum, which was basically a piece of advice, you could say, to any surviving consuls, suggesting strongly that they go ahead and choose a dictator. And so the dictator was the only appointed, non-elected Roman office. The dictator traditionally had up to 6 months to complete the task he'd been set, although it was also customary for him to set down his powers if he completed the task sooner. In the paper, I cover briefly what I've argued extensively in other work, that substantial informal constraints regulated dictators' power. And the Romans seem to have thought that on balance, they had little to fear from this institution as long as constraints like time limitation, the careful selection of the office holder, etc., continued to operate. And for 3 centuries, the Romans seem to have embraced the dictatorship as a good and useful institution. And our extant evidence strongly suggests that this institution was simply assumed to be legitimate. Of course, we don't have polling data of what everyday Romans may have thought, but we have several other kinds of evidence to support this claim. First, and most obviously, there's no positive evidence that the Romans did consider the dictatorship problematic. Now, any political scientists in the room would be quick to object that we political scientists now know that silence is not a sign of consent. Silence may instead be a sign of objectors' powerlessness. But anyone who's taken a glance at Livy knows how ferociously the plebeians, those Romans one might have thought were least powerful, contested other elements of the Constitution. as well as loudly rejecting the appointment of specific dictators in specific circumstances. In fact, some might say that the history of Rome is the history of less powerful and more powerful people arguing loudly about the Constitution. In this context, it seems likely that if there had been concerns about the legitimacy of the dictatorship, we would have heard about it. It's likely that the Romans took this institution for granted in a way parallel to how we assume that some kind of constitutional court would be a good idea. The institution was, after all, well, the dictatorship, common in governments of the region at the time. The Romans did not invent it. And furthermore, the dictatorship was just one among many intermittent institutions which the Romans made use of. The Romans often changed the institutional shape of their government for short periods to suit the situation. They would often appoint councils of 10 to do things like redistribute land or codify law. And there were also stretches when the plebs refused to elect consuls and instead elected consular tribunes, which was a right that they held. The Romans matched the institution to the task or the times, and recognizing that some tasks are time delimited, they had institutions that were similarly limited. And in this respect, the powers called into being when a dictator was in office were normal and not something that necessarily cried out for special legitimation. Finally, the institutional flexibility evident in the widespread use of intermittent institutions was part of an overall perception that an effective constitution or system of government has to respond to changes in political conditions. And amid the evidence we have for this, we find in Book 2 of Cicero's De Republica, Scipio Aemilianus, through whose voice Cicero is known to speak, explaining to his companions that, quote, "Our Roman constitution did not spring from the genius of an individual, but of many, and it was established not in the lifetime of a man, but in the course of ages and centuries. For there never yet existed a genius so vast and comprehensive as to allow nothing to escape its attention, and all the geniuses in the world united in a single mind could never, within the limits of a single life, exert a foresight sufficiently extensive to embrace and harmonize all without the aid of experience and practice." And Livy attributes a speech to the tribune Canaleus expressing similar sentiments. On the subject of intermarriage between the plebs and the patricians, Livy has Canaleus say, "Ought no innovation ever to be introduced? And because a thing has not yet been done, ought they not to be done, even when they're advantageous?" And naming a number of such innovations, Canaleus continues, "Who doubts that in a city built for all time, and without any limits to its growth, new authorities have to be established, new priesthoods, modifications in the rights and privileges of the houses as well as of individual citizens?" And this perspective is particularly noteworthy because it forms an explicit contrast with the Greek tradition of the wise lawgiver. It was something that the Romans considered special about their constitution, something that they thought contributed to its excellence. In this specific respect, the Romans were arguably more egalitarian than Americans. While many Americans attribute genius to the drafters of their constitution, placing the fruit of the founders' labor behind bulletproof glass in a shrine and crediting them with a superhuman wisdom and foresight, the Romans saw the process as a collective one that went on through time. Like the Americans, Romans prized the principles or values on which their constitution rested, but they saw these principles, rather than a document, as the root of the constitution. Constitutional innovations could thus be made on the basis of these principles, while the form of the government remained the same. And this was true until Sulla, whose example was followed by Julius Caesar. And then Augustus, in an important lesson, turned the Constitution on its head, keeping the form of government, the institutions themselves, pretty much the same, while utterly changing the essence of government in Rome. Constitutional change is normally grounded in arguments about principled continuity of some sort, and this remains true in Rome well into the imperial period. Even Canaleus' speech refers to the Roman tradition of innovation. Roman traditionalists who longed for the good old days weren't interested in a restoration of institutions as they stood following the expulsion of the Tarquins, but in the maintenance of Roman principles and ways of doing things, both of which could, over the course of time, shift. The very idea of the mos maiorum, the traditions of the ancestors, and the profound respect it commanded shows the the extent to which forms of traditionalism and forms of flexibility could coexist. Traditionalism is never pure originalism for the Romans. Those who, with Sulla, regretted pro-plebeian institutional changes never advocated a return to the past in institutional terms. Contestations in all these cases draw on aspects of innovation and aspects of imitation, and what they contest is the actualization of principles rather than an empty formalism about the proper shape of institutions. Sulla sought to restore the principles that he understood as underlying Roman government, not the original form of a Roman government. Because the prerogatives of the dictatorship were limited, because the institution was widespread in constitutions of the time, because intermittent institutions were a common part of Roman government, and because flexibility and adaptation were considered positive and critical aspects, it makes sense that prerogative powers, which were associated with the dictatorship, struck the Romans as just a natural part of good government. So the Romans didn't seek to actively seek to legitimize the dictatorship as an office because it wouldn't have seemed to them as something that actively needed special legitimacy. So this raises the question, what makes prerogative seem so strange to us? In sharp contrast to the Romans' understanding of their constitution, reference to the American Constitution is normally reference to a single written document. Constitutional scholars like Jed Rubenfeld argue that writtenness is inherent to solid constitutions, a valuable American innovation. And it's the assumption that the Constitution is this written document that makes many forms of originalism possible. While the citizens of many polities understand their Constitution as written, the centrality of its physicality as a piece of parchment a pilgrim can visit and revere is perhaps unique in America. If the Constitution just is that document, then change looks like corruption. And if the document, at its origin, largely got things right, then flexibility is all the more worrying. The issue of deviation from origins arises quite often in public discourse, as anyone who follows American politics will note. Could this focus on fixity partly explain prerogatives' legitimacy problems? If the form of government is perceived as set, then maybe any mode of flexibility looks dangerous. Consider Benjamin Franklin's speech of September 1787. He says, "I agree to this Constitution with all its faults, if they are such, because I think a general government is necessary for us. I doubt too whether any other convention we can obtain may be able to make a better Constitution. For when you assemble a number of men to have the advantage of their joint wisdom, you inevitably assemble with those men all their prejudices, their passions, their errors of opinion, their local interests, and their selfish views. From such an assembly can a perfect production be expected. The opinions I have had of its errors I sacrifice to the public good. Much of the strength and efficiency of any government in procuring and securing happiness to the people depends on opinion, on the general opinion of the goodness of the government, as well as of the wisdom and integrity of its governors. On this view, even if a constitution is less than perfect, the chance of improvement is not worth the risk of foolish or short-sighted changes, the mere proposal of which might shake the confidence of the people in their form of government generally. With Rousseau, we ought to believe a peak of wisdom was reached at the moment of founding, that somehow the men who framed the government had some insight or inspiration we can't hope to match. In America, the word founders is often capitalized, just like the title of another lawgiver we can think of. But these concerns about stability and its relationship to flexibility rely on the assumption that circumstances could not change so substantially that institutions would need to adapt. In Chicago, a skyscraper that was built not to move in the wind wouldn't stand for long. I think that's a good analogy. And while the widespread perception that America's Constitution is fixed persists, it's actually a false perception. And this is attested by a recent explosion of legal scholarship, which emphasizes the importance of constitutional conventions and other informal mechanisms in operationalizing nearly every aspect of the written Constitution. And I gather that Ben has written something to add to this chorus, or so he tells me. So far from fixity, then, the shape of American government does actually shift in the everyday course of things to best meet circumstances. If citizens were more awake to these empirical elements of fluidity and flux, prerogative as an institution might seem more legitimate. Stability doesn't preclude elements of flux and flexibility, particularly if flux is understood as normal. The stability of government is always relative to the conditions of government. If conditions change, but government remains the same, it may lose stability. De facto contemporary governments respond to these shifts just as the Romans did. And without the array of written amendments and the shifts in unwritten constitutional norms, America's constitution would arguably no longer be appropriate to govern a contemporary state. Stability is compatible with flux and flexibility because while laws and norms shift over time, the core can remain. The application of constitutional and legal rules is always anyway underdetermined. As we learned from Wittgenstein, going on in the same way is a deceptively simple idea. But underdetermination doesn't mean any old course will do. Constitutional change or institutional shifts of any kind, whether by formal amendment or the reform, abolition, or inauguration of a constitutional convention, must be done on the basis of grounds. The array of grounds on which constitutional rules rest are diverse, embracing text, history, policy, precedent, and morality. And the array of constitutional functions provide diverse grounds for contesting the meaning of constitutional rules and going on in an assortment of the same ways. In Canada, we've incorporated this idea of stability compatible with flux into a constitutional convention, we might say, embodied by the living tree metaphor. Certainly, fluidity and flexibility inherent in a tradition of innovation and implicit but apparent in the function of most modern constitutions can lead to conflict. But conflict is prerequisite to managing complex situations in a morally honest and fruitful way. When competing but legitimate principles and precedents are in play, opportunities open up to acknowledge the reality of moral and political conflict. The tensions in constitutional debate echo the range of functions and the range of values embraced by every constitution and every people. Throughout my work on crisis government, I've argued that concentrated power is not tyranny, even if it can be abused for tyrannical purposes. In Republican Rome, while specific uses of dictatorial power were certainly subject to public debate, the institution as such functioned as a natural and well-accepted part of Roman government, free from the legitimacy concerns that occupy us today. By contrast, prerogative in the American context has always had a legitimacy problem in theory, while prerogative has been freely used in practice. The idea of flexible institutions prompts fear for Americans. But I've been arguing that discomfort with the idea of prerogative as such stems in part from the centrality of the written element in Americans' understanding of their Constitution, coupled with the romance surrounding its origins. But institutions should be understood in time as things that develop, shift, and change, and as things that must be capable of responding to the inevitable short and long-term changes in the world around us. Crises, the unexpected and the urgent, are not aberrant, as we so often claim, but rather are a normal part of the course of government through time. This is so just as sickness is a normal element of the course of a human life through time, not an aberration. If we accept this, prerogative needs no extreme form of legitimation. It can be legitimized with reference to the same kinds of justifications for which any other action is undertaken. At the same time, the normative criteria governing the legitimacy of specific uses of prerogative must be observed and enforced with vigor and extreme care. So perhaps this betrays my too Machiavellian assumption of the place of regimes in time, but while our job is to do our utmost to ensure that good constitutions linger as long as possible at their peak, sooner or later, whether it unravels slowly or explodes spectacularly, every constitution fails. The instances where this occurred through an attempt to restore what was original is well worthy of note. And on that note, I thank you very much for your attention, and I look forward to your comments and questions.
Thank you very much, Professor Lazar. Professor Berger.
Well, it's a delight to get to comment in the Nathanson series, and in particular, a pleasure to have a chance to engage with Professor Lazar's paper, which is a very important set of questions, I think, about constitutional design, about constitutional history, about practices of government, which in a sense is at the heart of what the paper is about. And there's a fascinating core to this piece, which is the method of looking at Roman Republic for a number of reasons as a source of analogy and maybe inspiration about some of the attitudes that one could take to government in the United States. And of course, this is a particularly good time to get that kind of a lesson where TV is serving us up the lead-in to the ritualistically hybrid Roman monarchical inauguration that we're soon to see. And let me say at the outset that 2 points. One, I have very little to add on the Roman history, though I learned a great deal from it. And secondly, what I take as the heart of the piece, the kind of conceptual heart, is something I'm deeply sympathetic to, which is the desire, and you'll correct me if I'm wrong, but the desire to have a more complicated normative view of prerogative, that it has a more complicated sense of where it can fit in practices of government. And I think that's extremely important. I agree with that entirely. Professor Lazar is interested in drawing more inspiration in some instances, in some way, in some respects from the Roman system, as she suggests that U.S. constitutionalism should take more instruction from the Roman in some respects, at least in one dimension, which is a greater comfort with prerogative as a component of Republican government. Professor Lazar's sharp argument is that part of the explanation for the deep discomfort with prerogative powers in the United States, the reason that it is, as she says in her paper, so problematic for us, is the centrality of writtenness in our understanding of constitutional government. In this sense of fixity, she finds the U.S. tradition resistant to prerogative forms of power. So otherwise put, my understanding of the paper is that she sources the resistance to prerogative powers, the reasons why they seem strange, in our notion that a constitution, she says, is a single written document that delineates one shape for government. And so prerogatives, therefore, can seem like an attack on the Constitution in some form. So there are, if I understand correctly, two really principal pillars to the argument. One is that prerogative powers are resisted as not a normal part of government in the United States. It's not a form of the meaningful practices of a U.S. government. And then secondly, that the source of resistance to that is a sort of argument around writtenness, around a certain sense of the understanding of constitutions as relatively fixed and stable and resistant to change. And so what I want to do is kind of push on both of those two pillars a bit, both of them a little bit. And I have two kind of central avenues of exploration. One is more empirical, and one is a little bit more theoretical. Basically, I want to challenge Professor Lazar by noting that prerogatives, or suggesting to her that prerogative powers are in fact a significant and accepted component of U.S. governmentality, not resisted. And that's the empirical point. And secondly, that if I'm not correct about that, and if prerogatives are, as Professor Lazar suggests, resisted, the explanation, even the partial explanation, I think it's important to say that this paper is modest in its claim. It's not that this is a full explanation to the resistance, but this might be one of the bases. But it's arguably more complicated to lay it at the feet of writtenness. So in both, I'm going to just kind of throw a couple of things that are grist for your mill. So first, the first pillar, are prerogatives resisted in the U.S.? And so my first point of resistance is to that claim that there isn't extensive institutionalization of prerogative power and acceptance of that power in the United States. And the conceptual point that's kind of nested in this empirical point is that I think that the idea of emergency, which is an important contribution that Professor Lazar has made to the literature, that the idea of emergency as the paradigm of prerogative power might overwhelm the definition of prerogatives and arguably make it easy to miss the degree to which other forms of prerogative are operative in American government. Emergency powers are certainly one means by which government power has become consolidated in irresponsible forms of government. Absolutely. But I worry at points that the paper might make too quick an equation between emergency and prerogative, as well as between concentrations of power and prerogative. Prerogatives, I don't think, are either always about consolidations of power, nor are they always features of emergency. And so if that's right, and if we Catholicize our notion of what prerogative as sort of irresponsible exercises of power might look like, and it's the definition you gave very helpfully, you know, one sense, the sense of the kind of power exercised when law runs out. If you Catholicize the sense of how those might appear, I think we might say that there are in the United States exercises of government through discretion and irresponsible means that are not just extant all over US governmentality, but actually central to the understanding of the nature of the republic. And I'm speaking specifically about the United States. So let me just point to three. One is the pardon. The pardon is a huge feature of thinking about US governmentality and senses of power that misses the sovereign power over life and death, which is just crucial at all ends of, I think, US understanding of power. And the gubernatorial presidential pardons, I think, are a key feature that is not just prevalent, but accepted, debated, invoked, used. And this is an expression, I think, of prerogatives. It isn't just an expression, I think, of prerogatives. Historically, it is an expression of the prerogatives of the sovereign and a kind of historical hangover of those kinds of powers. So that's one. Jury nullification, right? Second crucial one. Central to the Republican appearance of power through the people, not just extant, but protected, coveted, accepted, understood, and a central part of American republicanism. And you could start looking for others, but I would point to things like veto, presidential veto power at the very heart of government, and other forms of irresponsible forms of exercise of power. So I worry just a bit here that the claim that the US is actually empirically quite so averse to prerogative powers can be sustained when you move outside of wartime emergency kind of styles of powers. And even then, even with wartime emergency exercises of power, from here, it can even then arguably be difficult to conclude that the US was quite as skeptical about the embrace of those powers when it mattered, in any event. So that's the first one, okay, which is, can we chat a little bit about the other forms of the expression of prerogative powers that seem to actually be not just extant, but central to understanding US forms of government? But this brings me to the second. Let's say I'm quite wrong about that, and that the description of the US as structurally resistant to prerogative or imaginatively resistant to prerogative is quite wrong. Sorry, that I'm quite wrong, that that's not correct. You know exactly what I mean. So let's turn to that claim that you can find a meaningful component of the explanation in the writtenness and sense of fixity of the US Constitution. And that's, the central sort of push. And I begin here by saying that one question that I have that I think would actually really strengthen the line of argument in the paper is precisely who you say is seized by that understanding of US constitutionalism. So there's points at which you seem to be referring to popular understandings or a kind of common mythology, right? That kind of pop understanding. Ultimately, I take it that your claim goes deeper than that. I say that because your interest is in practices of power and actual structures of choices and methods of government, a kind of political science of it. So I take it it's not just a pop sense of constitutionalism, though it does seem like that factors in some fashion. And although you cite scholars like Rubenfeld, I also take it that you're not, and I like this, not solely interested in elite interpretations or authoritative interpretations of US constitutionalism. And so my sense instead is that you're referring to a kind of conventional and more or less consistent, durable tradition of constitutional thought amongst those concerned, attentive, that have turned their focus to thinking about what is the nature of this tradition, right? Not just pop, not just expert, but some sort of idea about a tradition of thought. And To the extent that Professor Lazar says that these understandings condition American political and constitutional life and choices over time, that there's something about an R-ness of the understanding of our Constitution, I take it that must be what you mean, some sort of hybrid of those elements. So if that's the case, I just want to think about the extent to which the idea of fixity and writtenness has that kind of status, in fact, and whether there might be a more complicated vision of the U.S. constitutional tradition at play that is fairly mainstream, fairly old, very open to change, flexibility and unwrittenness, maybe as much as the Roman. And here I'm overstating, I'm pushing it a bit just to see. So, examples. Carl Llewellyn's sense of constitutionalism, extremely influential. The Constitution is anything that goes, right? Almost resonates with your paper.
I cite him, in fact.
Yeah. Ackerman, right? Also, Whittington, absolutely. So, if that appears to just be kind of current fashion, there's also thinkers from the 1850s and 1860s, Sidney George Fisher, who said that the Constitution, trying to kind of support Lincoln's use of wartime power, said the Constitution is whatever a government does, right? And that it's the supreme law to which government must conform. He said that all law is in the long run and is nothing but custom and recognized change 100 years before Ackerman did, right? Mm-hmm. Christopher Tiedemann later, similar sorts of things. Fisher, Tiedemann, Thayer, Llewellyn, Wilson, modern constitutionalists. So really the question is, what do you make of that line? As merely an exception or a hiccup, or with that kind of historical and thematic continuity, how solid can we be in the kind of conception of the U.S. Constitution as this one written thing? Or is that something that is actually itself a kind of moment in thinking about the U.S. constitutional law? So both, I think, fascinating. I think the argument is a strong one. I think that there are these points on both sides that I'd be interested to hearing a little bit more about. The only other point I'd raise has to do with the very nature of prerogative. And there's these lovely little points in the piece where you suggest that some degree of oversight or accountability might be fused with the exercise of prerogative that could really do some kind of ironing out of the difficulty. And time permitting, it'd be great to have a chat about what accountable and oversight mixed with prerogative actually looks like, whether or not this is oxymoron, or whether or not prerogative is inherently ungovernable in some fashion, as many hold, or whether or not it's actually something that you could squeeze together. So, as you can see, fascinating piece, clearly found deeply engaging, raised a couple of key questions for me, but I'm grateful for the chance to have the chance to engage with this, so thank you.
Well, thank you for those very thoughtful comments. What's the procedure now?
What's the procedure is, as you like, if you want to have a go at replying to some of these thoughts, you're allowed, or we can open to the floor. It's completely up to you.
Okay. Well, if you don't mind, I'd love to take 5 minutes and just throw a few more things on the table. So, first of all, with respect to the issue of sorry, apparently my notes are not very clear here. So with respect to your first point about the idea that prerogative, that we all too often conflate prerogative power with emergencies. Now it's interesting that you hit on that particularly, because I was writing this paper just at the moment when I began to become very interested in other forms of prerogative power. It's so I'm persuaded that this needs to be complicated in some way, and it's particularly interesting that you hit on that, because I was myself engaging in thoughts along those lines at that moment. Now, in terms of the question of whether these other more everyday exercises of prerogative are widely widely accepted, or who is it that's so nervous about prerogative? Well, with respect to the public in general, my guess is that this would be a perfect case where if you, if you were a pollster and you framed the question in one way, where you emphasized that this was prerogative power and explained what that was. Mm-hmm. This was somebody essentially either breaking the law or just exercising this free, unaccountable and responsible power, and then said, "Do you think this is okay?" You would get one answer, yeah. And and that the widespread acceptance of it might be, and again, we don't know until we actually go and look, right? Until we would actually perform an experiment like this. But my intuition is that if you expressed it another way, that probably people assume that these sorts of powers are legal and codified. Does that make sense? Or it would at least be interesting to find out, because my guess is that that most citizens would assume that these were legal or constitutional delineated powers, and that they would have a quite different reaction if they were presented as what they are. So that I put that on the table. I don't know what the answer is. I think I tell my moral reasoning students that a lot of the time when people disagree, it comes down to an empirical question to which we do not know the answer, and this may be one of those. So who is it that's resisting prerogative power? Well, certainly there are quite a few legal scholars in the United States who are, or at least people that I meet at symposia and things. And in one particularly memorable case, though of course I've forgotten the name of the person who said it, the strict insistence that no president had ever actually exercised prerogative power, which struck me as outrageous. Yeah. But there are lots of scholars who are very resistant to this idea. I think David Deisenhouse might not be upset with me if I threw his name in there among them. People who think that prerogative power is dangerous and unacceptable, is illegitimate. And that ties in with your second question. And I know I'm getting a little bit scattered here. I'm being very, very overtired and not very coherent. But so the second question, this question of who, is this really the dominant view in terms of flexibility? Well, that, to some extent, I have to defer to all of the lawyers in the room. I certainly, in my interloping into your discipline, did find a number of scholars refer to this view of the Constitution as the generally accepted view. And when you look at the recent scholarship that emphasizes emphasizes the fact that the Constitution is much more than the written document, this is always presented as something surprising, right? So it's never, okay, well, we all know that the Constitution is however it's practiced, and here's something else I have to say about it. It's all, now you guys all probably think that this is the case, that the Constitution is this written document, but now I'm going to show you how, in fact, it's something quite different. Is that fair to say? So right,
which was it is fair to say, I think, that there's that sense of it, which is why I find it interesting that, in fact, it's a very sustained, persistent claim that that's not at all what the Constitution is.
Doesn't Foucault at one point say something like, "We have not ceased to talk about how we do not talk about it"?
Yeah, no, and maybe that's the essence of the claim. Yeah.
That is interesting, and to some extent I do have to defer to you on that, because this is not the core area of expertise. But those are very thoughtful questions, and I think in particular raise the important fact that the paper is very speculative, and if I were to go further then say, and you're right to note that I was very careful to be a little bit modest in the claim, and that's because a lot of this, whether it's true or not, rests on empirics that we don't have, that I would have to seek out. So I think you, in other words, that you have found important and deep issues with the paper that would need to be established before it could be more than a hypothesis or I wonder type piece. So thank you very much for your thoughtful comments.
We'll open to the floor. I have a question from Professor Priel to start with. We'll need to pass around the microphone if that's possible.
Thanks. So I thought it was very interesting, and so let me see if I kind of understood the drift of your paper, and then I'll try to ask a question. So if I understood, you were trying to say, look, kind of who's afraid of prerogative power, and your answer is, well, in fact, it's the result of some kind of blindness that we suffer from, that we don't see that actually prerogative power is all around us. And once we saw that it's much more common than we think, it's just not called prerogative power, then we would start seeing that it's not, we shouldn't fear it as much. But if that's the case, then it might be argued that that there's still a difference, that you could say that, yeah, the Constitution is not the written document. And I think you don't need to be Ackerman with a constitutional moment story to believe that, but anyone who knows anything, say, about First Amendment jurisprudence in the U.S. knows that freedom of speech in the U.S. today is not what it was in 1850, say. And so there is a constitution outside the Constitution. And then the question is, okay, so what makes that constitution outside the Constitution? What creates those constraints? And then you can tell all kinds of stories about, so here too. One is a kind of Beckellian story that says that the judges are kind of reflecting the spirit of the people. If I hope I'm getting it right. So that the constraint is there, but it's coming from not from exclusively the text, but from the people. That sort of if constitutional adjudication works well, is reflected through the Supreme Court decisions. And another story is one that will say the Constitution outside the Constitution is natural law. And there is a tradition that said this in the U.S., in U.S. history. But then the claim might be that prerogative power is something that goes beyond these things. It's exactly where you're outside of constraints, and that's something that it's an extra step. So, the core is the constitutional text. Then the second step, which is still fine because there's still constraints, is the Constitution outside the Constitution. And what people are afraid of, the people that you speak with, and they're very resistant to prerogative, they'll say, what we are afraid is that the second step, not the first one. So. Okay, I have more things, but I think that's a good question. That's enough of a question for right now. So,
well, I think that a lot of prerogative is constitutional in the sense that it's part of the Constitution outside the Constitution. Now, whether or not we should be afraid of exercises of power that are either against the law or in where the law is silent, that go beyond the Constitution, outside the Constitution, depends fundamentally on whether these are abuses of power or exercises of prerogative, where the difference between those two is whether they're done for the sake of the public good. Putting aside just for a moment this fraught question of whether it's for the public good or not, often it's very clear whether it is or not. Sometimes, not so much. And we're never going to make that safe, right? But the idea that we should be afraid of that, even that other kind of power, as such, as opposed to afraid of its abuse, which I think are two different things. Again, just strikes me. It strikes me as peculiar. Why wouldn't we want somebody, if it really came to it, and we needed something that went beyond the Constitution, outside the Constitution? Why wouldn't we want somebody to take the risk, to bear the burden of office by putting themselves at risk of sanction, to do what had to be done, what clearly had to be done for the public good.
Can I make a suggestion?
Sure.
Which actually, but this is why I found the paper interesting, and I don't know, because you talk about Roman law, and I don't know anything about it. So, but what I found interesting is so the story that I know from kind of Republican writers of Pettit, etc., is that the fear is, is arbitrary power. And arbitrary power is exactly what happens, and that's something that you fear regardless of how it's exercised. It's the fact that you are at the what's the word? Wimp. Well, whim. Exactly. That's better than wimp. The whim of another. That you can and that's an infringement of your freedom, understood Republican way, regardless of whether it's exercised or not, right? That's why the slave is unfree even if the master treats him well. That's at least the story. So, and I took all these people to say we are just reflecting here the Roman story, and that and I thought, okay, that at least makes sense. But now you're saying that's not, in a way, not what the Romans thought. So that, to me, that's a kind of a challenge here about the history of what or history of ideas of what I knew. So I think there's something there that perhaps is actually worth saying a little bit more for someone like me who knows nothing about what the Romans thought about exactly this.
They clearly saw a difference between the exercise of prerogative power and tyranny. Those are two different things. And yeah, I think that there's an important lesson to be drawn.
Contemporary Republicans, because, okay.
Just going to insert myself here, and then I'll go to, is it Dr. Gillette now?
Are you exercising the prerogative of the chair?
Yes. No, but it's part of the rules, in fact. So, I'm just kidding. So maybe it flows a bit from Danny's question, and it might get back to it by the side. I'm not sure. It seems to me that there are two stories going on when you talk about prerogative, right? You say you define prerogative as an action for public good in the absence of law or against written law, right? So I can see that if we understand law or the Constitution as you're focusing on, the written law seems to be the written Constitution here. Well, there's the story that goes back to Plato that rules or legal rules are generalizations of what kind of behavior is justified, but because they're generalization, they sometimes won't apply correctly. A given instance, a particular instance of behavior will not be justified or ought to. The law ought to deal with it differently than it does. And if that's the case, well, there will always be situations that the law can't accommodate in its rules. For one, because it can't foresee that kind of situations, and as such, the rule will need to be broken or should be broken, given the kind of situation that it is. So that's the prerogative power that says, well, for the public good, you ought to violate the law, right? And then there's the other kind of prerogative, which is there are certain areas of behavior that should not be governed by law. Because I take it here, you're not talking about legal prerogative, which is something that is not subject to judicial review, right? The way you define it is a more kind of normal, moral prerogative. So there's this second story where you say, well, law should have no business here. You know, an army is perhaps not a good example, but an army, you could say, well, in combat, you don't need general rules, you need orders, you need people reacting right away, and so that's not a situation where law ought to govern, at least not in the same way. So I was wondering what kind of story you're focusing on right now. What should constitutions do? Should there be pockets of non-regulation, or should there be greater acknowledgement that the rules can justifiably be broken? Because this is two different prescriptions or two different diagnoses of the problem, right? You say, well, you ought to give more space for a kind of Section 1 story in the Canadian Charter, and the other, you simply ought to say, well, sometimes you need notwithstanding clauses, right? So these are two ways of accommodating changes that it seems to me are quite different. So that was the basic point. The other is just perhaps a trifle. You say the prerogative is not tyranny; it serves the public good. That seems to me to be a definitional fiat, right? You say,
yeah.
well, so it's good.
So that
that space, or that space where law is not present or one violates the rules, is good. So therefore, we shouldn't question this, right? And some people say, well, you say some people object to this. Well, it seems to me that these people, if really they're making the claim that you claim they do, are really objecting to virtue. And it seems to me that that's problematic. What they object is to the bad use of prerogative, right? Of Nixon standing up and saying, you know, I'm the law and this is what I do. It's hard to object to as it were morality, right? But it's easy to object to particular instances of behavior. So I'm curious to know whether these scholars are really objecting to virtue, as it were.
Well, in a word, yes. I mean, not just scholars, but people in general,
Okay.
I think. So the reason why we prefer a rule of law regime to a benevolent dictatorship or I should say, there is a reason why we prefer a rule of law regime to a benevolent dictatorship. As a normal mode of government, the idea that actions which are not dictated by law or which are not sanctioned by law, even if they're for the public good, the idea that they aren't sanctioned by the law it makes us uncomfortable. We don't want a government that's run that way day to day. If that makes sense?
Yeah, sure.
Okay, so I think it may even be safe to say that we all object to some extent to the idea of power that's exercised for the public good without legal sanction, and that we want, you know, the idea that why we prefer a rule of law regime is that it relegates this kind of thing to a smaller and smaller space. So it is true, as Ben brought up, that prerogative is everywhere.
But what is that kind of thing? Is it the violation of the law when it's justified, or is it law should not be there?
Well, both. It depends on the circumstance, and the whole point is that you can't say in advance. So there are cases where people, leaders and others, should break the law for the public good, and where while that should remain legally wrong, we might say that it's morally required.
Right. But there's no problem with the other. If there's no law, then presumably they can do whatever they want.
No, not necessarily.
Insofar as it's morally justified, right?
Well, I mean, I'm not sure that we necessarily understand government in that way. So if there's no law sanctioning, for example, so a good example of a prerogative power in Canada is the prerogative of the Prime Minister to declare war. Okay, so the Prime Minister in Canada has the prerogative to declare war without legal sanction. Okay, now a lot of people are very uncomfortable with that, and maybe justifiably should. So they feel that there should be a law giving the Prime Minister the power to declare war, thereby making it more democratic in some way. Does that make sense?
Right.
So that would be an example where a prerogative that may seem justifiable to us could be, for some reason, the cabinet can't meet and Parliament can't meet, and the Prime Minister just needs to declare war now. That could be what would seem to us to be a justifiable instance of prerogative, meaning that it really is for the public good when we're talking in this moral sense of prerogative. But otherwise, in normal circumstances, we might think that it was preferable, that it wasn't just okay for the Prime Minister to declare war unilaterally, but that it was preferable for there to be some kind of legal backing. Does that make sense?
Okay, so the more this conversation has gone on, the less certain I am that my question is going to be helpful or interesting at all, but I'm going to ask it anyways. So we're talking about prerogative, and there's a little bit of an ambiguity in this concept between a power given to an official to act without guidance. There's a sense of prerogative at play there, and that, I think, is what we think of when you talk about presidential pardons, right? Then there's those acts that stand outside the law, and I thought the second set was more the focus of your paper. Now, my question regards whether this flexibility-fixity issue is the best account of what explains our hesitation or our concern with those extra-legal acts of prerogative. And rather than looking to Roman law, I mean, my inclination was just why not look at American law, and why not look at an explicit act of prerogative in American law, and then examine the complaints that people make against it. And the best one is Marbury-Madison. The Supreme Court of the United States of America took for itself, without any legal justification, the power to review the laws. And it seems to me that in every complaint lodged against that case, the issue is not one that, well, our Constitution shouldn't change. The issue was, you're acting undemocratically. You're acting against the public will. There is no public good without a public determination of what is constituted, or what constitutes it. And it seems to me that that concern is the very same concern that's at play in legal instances of prerogative. Why do we get concerned a little bit about the president giving paroles? Because he might not be acting on the basis of the public good. So it seems to me the very same concern can be identified with regards to both kinds of prerogative. All right? So my question is, why doesn't that seem more plausible than fixity flexibility? Maybe, for one thing here, is that there is a sense in which when we get into conversations about public good, and we start thinking in terms of that there is a discernible public good out there that is distinct from any of our democratic considerations, that is distinct from, that is, kind of objective morality. It's just it is out there to be found, and as long as we're doing that, you're legitimated. But that does beg a certain kind of conception of political justice, among other things. And I'm not sure it's the one that's at play, especially in American politics, all right? Whereas it would have been the one that was in play in ancient Rome.
Okay, I stopped following you just at the
Okay,
end,
so
stick
if
to
you
the-
think of, sorry, this is coming to me as I was asking, so I thought I'd throw it
Okay.
in. But the idea would be that when we're talking about the terms of the public good at play in ancient Rome, my understanding, and maybe I'm incorrect here, but my understanding was that there was a sense in which they have this sense of call it right reason, okay? Something that stands outside of ourselves or stands outside of our collective determinations, and that somebody can coherently act on the basis of something outside of the democratic will and call that the public good. Whereas in America, if you take them to be, have a strong Kantian background, that's nonsensical. There is no public good outside the public determination of what it is.
The Bible.
Huh?
The Bible.
No, remember the Bible. The Bible is now not when the Constitution was framed. Right? They weren't being biblical. They were being good Kantians. It just seems to me there's so much going on here that fixity flexibility is maybe, but aren't there more compelling stories out there already?
Okay. Now, just remind me, did you read the paper or?
I read the paper.
You
Yeah.
did? Okay. So it is certainly true. Well, okay. So it seems to me, as an initial snapshot, that a lot of what you're getting at, but not all, but a lot of what you're getting at is why what the criteria are for us to judge whether a particular use of prerogative power is a good one or not. So we can ask, is this presidential pardon justifiable or not? Is this in the public interest or not? Or is even that whole prerogative power, we could say, is this in the public interest or not? And so I tried in the paper to be very clear that I think that while there's spillage, okay, from one set of concerns that are the set of concerns that say, look at all these bad instances of the use of prerogative power, or look how dangerous this power is, and it's easy for that spillage to influence our sense of whether prerogative power as such could be legitimate or not. But that in itself is not enough. Do you see what I mean? That said, I do think that the last issue, so if it's really true that there is nothing which could count as the public good, then prerogative power is in trouble. I guess I'm not convinced that that's so, but, or okay, sorry, you weren't saying that exactly. You were saying that the public good must be defined by democratic.
That it's that idea that stimulates American concern. Not that idea is correct, but that idea, right, is what stimulates American concern with these illegal or illegal activities. So,
Okay,
sorry.
except that normally, well, I shouldn't say normally, but not infrequently, exercises of prerogative are subject to some kind of post hoc ratification,
Right.
which is basically the process by which, or through which, the public basically or decides whether this was in accordance with the public good or not. So I don't think that the two are necessarily. I think they can sit together. The question is, does the public ratification, or is the public does consent come first or after? In a nutshell, does that make sense?
It does. If I can just one more point to
sure.
follow up on this is just the idea that suppose that what they're concerned with, this remember is a challenge to the issue of whether it's flexibility that's really the underlying concern here. But
and I also want to emphasize again that
that's not the only piece,
right.
but that's the piece you're focusing on. But I guess the question I'm raising, and I don't have this well worked out, this is just for the sake of
It's
bantering back and forth,
helpful for me too, so go
is
ahead.
just let's talk about, and this the reason I began with a difference in two kinds of prerogative is the following, that your work seems to me to be offering an account of prerogative generally. And I tend to think that American concern is located predominantly in these illegal or illegal acts of prerogative. And the concern, right, and so when you have an illegal act, right, or an illegal act that then gets brought back under the fold, right, it's retrospectively ratified, okay? What's going on there is that they grant it democratic pedigree. And that's how they talk about it, I mean, as I understand it, right? And so it seems to me that democracy is the motivating ideology that stimulates the concern, and that explains just why we feel okay, right? Extending ourselves sometimes into places where the law hasn't been made explicit or is not yet determined it, or it recognizes a change in the democratic will that, oh yeah, that was the one that was on the books, but the democratic will really would let us buy Louisiana or whatever.
Right. But I think now we're agreeing with each other.
To some extent, the issue for me would only be that, is this really a matter of fixity or flexibility, or is that story kind of tangential to the main issue, which is that really the concern that distinguishes the Americans from the Romans is the Americans have an obsession with democracy on a certain understanding of it.
Okay, so I'm not convinced that I'm not convinced that's so, partly because the democratic element, as you yourself just said, can come into play. So the idea that prerogative is okay to the extent that there's either to the extent that people forget that it's prerogative, which I think is the case with things like presidential pardons.
Therefore, presuming that it is democratically
exactly.
acceptable, right?
And my guess is that you would find overwhelmingly that people thought that it was and did not realize that it was a prerogative power. And to the extent that it is acknowledged, that exercises of prerogative power are acknowledged to be such, the idea that they're made okay by some kind of democratic post hoc exercise just shows exactly what I've been suggesting, which is that there's nothing about a democratic republic that precludes the exercise of prerogative power. And you've just given one answer to Ben in the question that I forgot to address before, in terms of, well, how can we have any kind of, how can we have accountability for prerogative? Well, various forms of post hoc ratification is one example. So that I mean, it is certainly true that. So, okay, I think I'm getting at it now. So you think it's because prerogative is perceived as non-democratic that it's rejected?
Especially, or maybe, only in those extra legal instances, or particularly in those extra legal instances. We might be worried about it if it's a legally granted power without guidance, but we're not nearly so worried about those instances as we are when you've just gone off the reservation, excuse the term. All right. And the idea would be that, so I'm not suggesting that, first off,
I'm coming around.
So I wouldn't deny that maybe there is a justification for prerogative, even of a extra legal or illegal sort. Right? Maybe it is true that our democratic will, if what you're really doing is just matching up the Constitution by an act of prerogative, or changing our institutional structure by an act of prerogative, illegal prerogative, to better reflect the democratic will, maybe there is a justification there for it. But just that the argument is not going to be about, maybe flexibility is just a way of talking about better representing our democratic will or something.
Well, I guess, yeah. I mean, I don't think that the two are mutually exclusive, because I mean, it's clear that some people like David Deisenhouse who hate this stuff, right?
Yeah.
It's on a rule of law basis. So he's not talking about a democratic basis, but it's a similar structure. So this is not in accordance with the rule of law.
Yeah.
And so the answer to that, so the idea that democratic forms of government and prerogative power are mutually exclusive, or rule of law systems of government and prerogative power are mutually exclusive. I think it's almost So in both cases, I want to suggest that these are just instances of the de facto flexibility of these forms of government in accordance with higher principles. And so I guess my question is, when and if someone accepts that, why do they remain resistant to the idea of or why do they remain resistant? Partly because it suggests that our form of government keeps changing its shape while remaining basically the same form of government. Now, that said, because I'm now teasing this out in my own mind and not, that said, that's an excellent question that I'm going to give a lot more thought to, because it's not fitting together for me quite yet. So thank you very much. Very helpful.
Professor Creel again, and then we'll move on to Professor Davis.
So Matt helped me in one way, but ultimately I have some issues. So Matt helped me in the sense that it helped me understand how the Romans could justify prerogative power with their idea of republican freedom, which is that even the dictator is not completely free. The dictator is subject to natural law. And that fits one of the two stories that I suggested to you that could keep the president, say in the American context, constrained. And there is a long history of a suggestion that there is a higher law, the higher law aspect, which is part of the Constitution. So just a name of one, the higher law background in American constitutional law, an article by Corwin in 29. Do We Have an Unwritten Constitution by Thomas Gray in 1975. These are all works that kind of, and others, Susanna Sherry in 87 or something. So there is a line of work that suggests that kind of natural law is part of the American Constitution, and that could give the kind of constraints even when you're outside the Constitution or the expanded Constitution. Or sorry, that in a way you're never outside the Constitution, so you're never really acting without limits. And then I think, but I think with the decline of these natural law ideas, or with the decline of the idea that they could constrain us, then the worry arises and becomes more prominent. And it's not a democratic one. I actually, that's the point where I less agree with Matt, because so think about the build-up to the war in Iraq. There was popular support for Bush. Of course, there was a lot of people who didn't, but I think there were majorities who supported him. But those who said not declaring war through Congress, for example, or acting in certain ways, that the problem here is not so much that there is no popular support, so someone is a dictator even if he has popular support. I think that the worry is more the idea of the decline of the Republican idea of self-government, which is sort of in the DNA of American politics and goes back to Roman Republican ideas. And then now with Matt's help, I see why the Romans could have solve the problem through ideas of natural law, and you don't like this.
No, I don't. Sorry. Dictators. Well, first of all, they would not have discussed this, I think, under the in that kind of terminology. But I guess listening to you, my first response is: who was ever constrained by natural law, as such? I mean, so it's certainly true that if you ask I remember when I was doing the research for my doctoral dissertation, and I talked to the woman who had been the mayor of Winnipeg during the Red River flood in '97, I think it was. And I just wanted to talk to her about what it was like having all of this power, basically. And at one point I said to her something like, were you ever tempted just to pick up that guy and put him in jail overnight that had left his garbage can on your lawn back whenever? I didn't put it quite that way, but, and she was just like, no, of course I wasn't tempted. It didn't even occur to me. And my guess is that any one of us in this room, I hope, should we find ourselves in a similar scenario, it wouldn't cross our minds either. And I'm not sure that I would say that that's natural law per se. Maybe just sort of a generalized morality or sense of civic responsibility or something. But for the Romans, the constraints on the dictator, the reason why they weren't too worried, yes, there was this sort of morality, sense of civic duty, but there were a lot of very real political consequences too. And I certainly would never, despite my first degree in philosophy, enough study of politics beats out of you the idea that you can just sort of figure out, okay, yes, it would be just and therefore we can allow it to happen. I mean, you want some engineered constraints, but those constraints don't have to be legal constraints. They can be political constraints that are informal, that are incentives and disincentives. One example that's is so in Britain, for example, with terrorists, so dealing with terrorists. So there's nothing which directly constrains the Prime Minister from doing certain things with suspected terrorists, but the knowledge that after the fact someone might, we don't know what the law is yet, but someone might bring a challenge to the European Court of Human Rights, engineers certain behavior, right? So this is not a legal constraint per se. This is because there's no law which says you must not do this, right? There's merely the threat of some future possibility of new law arising. Do you see what I mean?
That's
in the border zone, closer
okay.
to formal constraint.
I think I spoke to so here's a suggestion. Are you actually less conceptual than you're suggesting and more normative in the sense that you would say you may want to say my idea of prerogative or prerogative is fine and we shouldn't be afraid of it so long as there is some kind of constraint.
Well, okay, we should always be deeply afraid of specific uses of prerogative power, always. No matter, because we'll never be able to engineer constraints that are effective. We can engineer constraints that are more effective or less effective, or somewhere in the middle. But there simply is no way to decidedly determine the behavior of political actors faced with any given scenario. It's just not possible. So I guess what I want to say is, if we, there's a large class of behavior, which is action without the sanction of law or against the law. And within that class, we have two subclasses. And one is called tyranny, which is, I am defining as those acts within that, that larger bracket, which are for personal gain or some other negative, not so nice thing that someone might be after. And the other, and by definition. So among those acts, any act which is not for the public good is tyranny. And any act which is for the public good is by definition prerogative. And what I've been arguing for is that the idea that there could be this class of actions which is prerogative and is consistent with a democratic rule of law regime or a constitutional republic, that's a legitimate notion. Okay, does that make sense?
Yeah.
Okay.
My concerns are just about exclusively lexicographical, I think.
Okay.
Just that I want to know, who's been using the word prerogative and how do they use it? And I'm used to hearing the word used in a particular narrative of British constitutional history, where prerogative isn't really necessarily associated with emergency powers at all. It's just those are the Queen's inherent powers, right, over a long span of history. And over the centuries, it's been those powers have been constrained by Acts of Parliament and limited by Acts of Parliament, and and additional powers that were not part of the prerogative have been granted from time to time. Lots of statutory powers, and if you look in the Canada Gazette for regulations issued other than by statutory authority, you find little things like declaring it National Mothers Week or something like that. It's those few powers remain in the prerogative, and they have nothing to do with emergencies or anything. They're just those few inherent powers that the Queen has by virtue of being Queen, whether that's by the grace of God or however you define that. But it has a lot to do with origins. What's the source of that power? And that's where I would start in thinking why the Americans are so resistant to thinking that the president has any prerogative powers at all. Because the president does not act as the successor of George III. George Washington, and they would very much resist any idea that George Washington had any power as the successor of George III. They would say instead that all of George Washington's powers were given to him by the people. And it's the origin of his powers, that he would have no prerogative authority. But instead, that by making George Washington commander-in-chief, that was a broad general grant of great authority, not all the details of which could be spelled out.
Well, first of all, just out of curiosity, do you know the work of my colleague Philippe Lagacé on Canadian prerogative?
Okay. I don't.
He's just started working specifically on prerogative powers and the prerogative powers of the exercised by the Prime Minister, and his catalog is quite a lot larger, and for people scared of prerogative, and even for me, more distressing than.
Well, there are some big ones.
Mother's
As the example you gave, the power to declare
Yes.
war.
Yeah.
But my question was, I mean,
yeah.
just to finish the question,
Uh-huh.
I was wondering, like prerogative seems like it's a Latin word, and I'm just wondered, during most of what we know of Roman history we have from the Republic, and I'm just wondering, who did the Romans say had prerogative or whatever cognate word they used?
Well, I'm going to confess that my Latin is bad. I mean, it almost certainly is of Latin origin, but it's not a word, at least in English translation, that is that you find used in discussions of Roman constitutionalism. Now, so two things that I would raise here, and one is, first of all, so it seems to me that when you read the scholar or the political thought of America's founders, they are first of all concerned, just as the Romans were, with having an office that could fulfill some of the roles of the king without actually being a king, and the Romans were up to the exact same type of activity. And it's also, so I mean, they're self-consciously trying to figure out, well, we don't have a king anymore. We don't want a king. We think kings are dangerous creatures. But we still have these kingly functions, and we need those executed. How are we going to go about doing that? So it's not clear that the sorts of power that we would pick out and say that's prerogative power in the Roman Constitution count as an inheritance from the Tarquins per se. It's more like a pseudo kingship, you could say. And what's interesting in the American case, where it is much more self-conscious and self-consciously emulating to an extent Rome as well, is that so not all, right, but many of America's founding fathers are talking about prerogative in one way or the other, or at least assuming that some kind of power like that has to be inherent in the office of the president.
I'm just wondering if they used the word.
If the American founders use the
Yes,
word?
did
Yeah,
they?
some of them do.
They called it a prerogative.
Yes. Yeah. Some of them do, for sure. But they're nervous about it. And then, of course, if you read the debates, right, there are other people like Clay who are horrified at the very suggestion. But yes, the American founders are calling it prerogative. The Romans, not so much, but you can certainly pick out instances of its exercise. And it is sort of institutionalized with this dictator.
Professor Berger.
Do you have time?
Oh, yeah, plenty.
Oh, okay.
Pardon my surprise, but do we go on until 4:30?
4:30, yeah.
Oh, okay.
2 hours, 7.
All right.
So first of all, I want to kind of anchor back to the notion that I think is most like kind of at the heart, and why I think that you're absolutely right, and why the work is so important to say, draw the distinction between the existence of a prerogative and whether it's exercised positively or negatively. I think this is crucial for a number of reasons. Most importantly, because, and I couldn't agree with you more, you should always stay kind of concerned and afraid about the prerogative. And the main point is that these things, in my view, and this is just by way of agreement with you, these kinds of points of discretion, these points of a responsible power or arguably exercise of power against the law, are potentially tyrannical, but also potentially merciful and felicitous. And that leaving open the space for the merciful, felicitous forms of it also leaves space for the tyrannical and dangerous forms of it. And so I think you could just as easily describe it as, I don't think you'd object to the statement, prerogatives, exercised tyrannically are to be feared, and prerogatives exercised mercifully or benevolently are something you might want to covet. And so I think that leaving that space open is such a crucial project, conceptually open, that pushing back on those points of resistance, of unthought resistance, right, to where these real practices sit is really important. So I just want to kind of state that I think that that's the heart of the kind of deep logic of your project, is to get at a normatively more complex approach to these practices of government. No question in that at all. I don't have a question for you in that, just to say I think that that's great.
Okay, well, thank you. The only thing I would just quickly note, just again, and this gets back to Francois's concern about the definitional fiat. In my conceptual scheme, the moment a prerogative power is exercised for tyrannical purposes, it ceases to be prerogative and becomes tyranny.
And that's fine. I'm okay with that.
You're okay
I
with that?
wouldn't describe it that way, but that's just a pure description. I think conceptually we're on the same ground.
Okay.
I wanted to make a couple of suggestions just for thinking. Number one, to add to the picture, prosecutorial discretion as a instant that happens on the ground, day to day, moment by moment. That is unregulated, unruled, and is kept to be unregulated and unruled, and in a bunch of countries, including in the U.S., and accepted, and all of these sorts of things. So alongside these other practices, and kind of underscoring that push away from emergency to try and add those things, I'm just adding something to the catalog. But one thing I would say is that I do think that the paper is its most interesting if you stay away from the instances of the post hoc ratifications. That
You don't like those?
I think they're the least interesting ones, because they are the ones that involve the kind of least problematic of the class that you're dealing with, because they absorb in some form, and there's a clear reason why they appear so much is because, again, that's an artifact, I think, of focusing on emergency powers and wartime powers, is because they're the prerogatives that tend to get post hoc ratification. But all these other ones that I mentioned, right, jury nullifications, pardons, prosecutorial discretions, there's no kind of post hoc ratification, yet they remain an important part of practice. And so I just want to encourage you to, those exist, and it's interesting to think about them. I don't think they're your most interesting case.
Yeah, and just to throw another one on the table, just in terms of the class of things that's now puzzling me, although I keep saying I'm done with prerogative power, is eminent domain. So seizure powers, so I taught a session on this in my limiting rights seminar last year, and both I and the students were horrified to learn that the only point on which you can appeal is the amount of money offered if the city or province or Canada takes your property. You can appeal how much money you're given. You cannot appeal whether your property is seized or not.
You mean expropriation?
At all. What, sorry?
Expropriation law.
Expropriation, yeah, or, yeah. And the appeal hearings are closed. So if you want to talk about arguably that's a prerogative power.
Maybe,
And-
yeah.
And in terms of any kind of accountability or oversight, I think it's a particularly striking one.
So-
but I'm not a lawyer.
but keying into that and just
always
to-
being a lawyer and a non-lawyer in a room full of lawyers is very
Very few of
intimidating.
very few of the points I've made are particularly legal in any sense. But and I would just say I actually think that there's a lot of promise. You can tell a Roman story, and I think you can also tell a British story about anxiety around this. And so the one classic form of sort of prerogative hangover in North America, in the United States, and in Canada is equity as the quintessential example of a prerogative structure of government. It was spoken about in that way. It was extremely monarchical in its kind of conception, and it is, I think, a real imprint on the structure of our law now. And so I think it's really interesting to think about there being a Roman influence, but there's also an Anglo-North American kind of arc of talking about prerogatives that I think is might kind of sustain and enrich the piece as well.
Yeah, that's interesting. Also, not to bring Rome into it again, but one of the most important prerogatives of the people of Rome was precisely they held the pardon power, and that was one of their most fiercely defended rights was their prerogative to pardon somebody who had been sentenced to death. Nobody could be put to death in Rome without the consent of the people. So well, all right. But I take your point. I think it's an interesting direction to pursue. I'm not sure whether I'm gonna.
No.
Right, so I'm trying to make sense of a number of comments and your responses to them. I'm still trying to make sense of what the evaluative benchmark for what's going on here is. You seem to insist a lot on the public good, right? You say if there's no public good, then there's no space for prerogative, or that discussion is futile. Acting in the public good is really what is the evaluative marker, as it were. One could say acting morally. Now I ask myself, well, is that coherent with democracy or with a written constitution? Of course it is, because democracy ought to be exercised in the optic of the public good. If not, it becomes the tyranny of the majority, right? And so is it really the public good, or is it, like Danny says, is it self-rule? And in a sense, I thought that's what Matt was getting at in a different way. And if it's really self-rule, then it seems to me, again, there's no problem so much as, well, you could say, people can realize that the procedures that we have, or that Rome has, are not always going to be the best ways of administrating, of ruling ourselves, or of attaining the public good, as it were. Sometimes we don't have time. Sometimes it's just not the best way to regulate, right? We could get at where we want to go better through incentives, or through conventions of honor, or there might simply be too many conflicts of interest, and so on and so forth. And then you say, well, the Romans were quite comfortable with the dictatorship, or with so-called prerogative, because they were effectively checked, right? And why were they effectively checked? At some point you say, well, at some point there's this point in history where it seems that although the dictator was not overthrown, there's a sense that it could have been, and this is why, at least that seems to point out to the fact that, people were comfortable with the fact that were possible, and that idea of self-rule was still looming in the background, as it were. It's possible for people to govern themselves directly through democracy or the institutions that they have. It's also possible through self-rules for them to adopt a certain set of checks and to be comfortable with them. And so self-rule, again, here can be a possible benchmark. I'm just not sure I understand what the problem is if public good or self-rule are the benchmarks. Or maybe there's something I'm missing, but let me just put this on the table.
Okay. Just as a small point, so at one point, the people of Rome
Right.
did actually. I mean, they didn't.
Okay, yeah,
they didn't
but-
physically force the dictator
Right.
to, but they
Right.
beat him down and let him, and he chose, given the available incentives, to actually leave the office. So and other evidence for their, and I know this is not getting at the conceptual point
Right.
that you're trying to make, for the power of the public over a dictator is the number of times that dictators, even though they're appointed by the Senate, by the patricians, become panderers to plebeian interests. That's a theme that comes up again and again and again, so that they cannot complete their task without the consent of the people, and so they basically engineer the consent of the people by acceding to their demands of various kinds. So, but in terms of then, okay, I'm going to confess I'm not entirely sure that I.
So
I've
you,
lost
you, said,
the thread.
you said at some point, you said, well, my project is really to try to reconcile prerogative with democracy, right?
Well, more with the
mentioned-
rule of law.
With the rule of law?
Yeah.
Okay, understood as a thin version of the rule of law, or the rule of rules, basically.
Well, no, more with the robust version of the rule of law, that we could be a rule of law regime, that is, we could have the rule of law, and at the same time we could have rule without an explicit rule, if that makes sense. So that one man or one woman could act in a way that in that instance did not seem to accord with a narrow conception of the rule of law, because it was not, it was either illegal or lacked the sanction of law. So it might look like arbitrary power.
Right.
And then I want to suggest that it's not necessarily arbitrary power, so long as it continues to accord with the principles underlying the rule of law.
So, which is
that's
that public good?
No. So and that's getting back into the
Okay.
into the book,
Okay.
not the paper.
Okay, because I'm just thinking Timothy Endicott has a really good article where he says the rule of law is there are really two questions here. There's the question of the rule of rules, using rules to regulate certain things, and the fact that makes regulation more predictable. People can organize their life around the rules that apply to them, and therefore can avoid sanctions. And so that's one story. And the other story is the story of whether rules are the best apparatus to govern in a given situation, right? And it's not so clear to me that in the paper you differentiate.
No, well,
But-
this paper is. I mean, so that's an argument that I'm engaged with in my book.
Okay.
And so that question in this paper is
Right.
definitely bracketed and put aside.
I see. Okay.
So see, just one more reason why
Yeah.
screw the thesis.
Okay.
You've got to read my- No, I'm just kidding.
That's good.
So that's just one more advertisement for you to buy a copy of my book, or take it from the library.
Anyone else? If not, I would ask you to join me in thanking Professor Lazar for a very thought-provoking paper. That was great. Thank you.
And thanks to all of you. Those were great, really thought-provoking and engaging questions. Thank you.